Good morning, everyone. Good morning. Good morning. Come on in. Instagram, Facebook, YouTube. Hello, 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 everyone. Comment in the box. Let me know where you're tuning in from. If this is your first time, definitely let me know where you're tuning in from. I'm in cold Atlanta today. It's super cold today. Um, there's really no difference between the cold weather here today and New York. So like whenever people say, Atlanta is cooler, I don't know about that. I mean, it's warmer. But good morning, guys. I have a really good topic today. I just want to jump right into the topic. You can definitely put your questions in the comments, and I will answer them once I'm done. Thank you so much. The person that said, I love your hair. Thank you. And Rumba from Jamaica. Thank you. Portia from Connecticut. Good morning. Russian from NYC. Locke from Cold NY. And Olu from Chicago and North Carolina and Bahamas. Good morning to you all. I think it's cold everywhere. There's like a cold front or something like everywhere. Thank you so much, Fresh Coup. So for those of you who don't know me, my name is Aisha Chidole. I'm an immigration lawyer. I represent clients all over the U.S. with their family immigration matters, humanitarian-based cases like VAWA cases, T visas, U visas, naturalization, fiancé visa, consular processing. Basically, we do almost everything on the family side. If you want to schedule a consultation with me, definitely call me. I'm 407-995-6567. You can also send a WhatsApp to 404-333-8751. Our number is in all of our profiles, our Instagram profile. The only Instagram profile we have is the verified one with the blue check mark that says Immigration Attorney Aisha, and on Facebook and YouTube. Someone says it's snowing. Oh my goodness. My kids will love to see snow. They still have not seen snow. Well, they've seen snow, but they've never seen snow falling. They want to see it falling. But today I want to talk about qualifying for a 10-year green card as a child through VAWA, because that's one area that we don't talk about a lot, but so many kids qualify for it. We'll talk a lot more about spouses, but let's talk about how your child can get their 10-year green card through VAWA if they're eligible. So first of all, again, VAWA is Violence Against Women's Act. Even though the name has women in it, it covers men, women, children, same-sex marriages, and all of that. Today's focus is really going to be about children and what the requirements and the qualifications for children are. So the first requirement is that the child, in order for a child to self-petition for a 10-year green card through VAWA, is that the child must have a parent that's a U.S. citizen or a green card holder. So that's the first requirement. Second requirement is that the child must be unmarried. You must be unmarried when you file your petition and when they make a decision on your petition. The other requirement is that the child has to submit the application before the age of 21. Now, there's a small loophole there. So basically, if you submit it before the age of 21, no problem. You can submit it, no questions asked. But if you do what we call a late filing, meaning you submit it after the age of 21, you can technically submit it between that 21 and before you turn 25, if you can show that the abuse was one central reason why you didn't submit the application, and that the abuse took place before you turned 21, or at least started before the age of 21. This is a critical one. I want to actually go back to define what a child is when you're trying to determine if your child is eligible for VAWA. So the first one would be, of course, any children born in wedlock. So if you were born biologically by your mother and your father, or mother and mother, father and father, whatever, you were born in wedlock, and you experienced abuse from one of them, you will be eligible. The second qualifying parent-child relationship is stepchildren. So stepchildren who were born in or out of wedlock. However, here is the caveat. If you're filing this, I don't know why my screen is so bright. Like, I don't know what to do. Let me turn off my lights and see. Now it's so dark. I don't know why it's so bright. But anyway, going back to stepchildren, in order for you to petition for VAWA against your step parent, you must show that your mother or your father married that step parent before the child turned 18. This is non-negotiable. If this applies if the child is a self-petitioner. You can also qualify for VAWA through your mother or your father if they're the self-petitioner, and you can do that before you turn 21. And it doesn't matter if your parents were married before you were 18 or not. But today I'm specifically talking about self-petitioners, you as a child self-petitioning, not as a derivative, okay? Another category of children that will be eligible for this are adopted children, provided that the adoption was finalized before the child turned 16, or if you're a sibling of a child whose adoption was finalized before they turned 16, that you basically were adopted before you were 18, and you both have to be from the same parents. So basically, brother and sister, or sister and sister, or brother and brother. So that would be considered under adopted children. And then the other requirement is that if the child is born out of wedlock, the child has to be legitimated, right? So you either have to be legitimated, and what does legitimated mean? Legitimated is different for in every country, but basically, what do you need in your country to be able to show that this person is a legitimate child? Like, do you have to do a paternity test? Do you have to put your name on the birth certificate, and stuff like that? But you can also show, if they didn't do that, that the father has or had a bona fide parental-child relationship by providing evidence of those things, okay? To be able to do it as a child born out of wedlock, and you fall into that category. As far as living with that parent, thank you, all of you that's saying you love my hair. Thank you so much. There is no requirement that you must be living currently with your parent or the step parent or adoptive parent or whatever. As long as you lived with them at some point, even if it's for short summer vacation. So let's say you have a parent who maybe is abusive and sent you back to the home country, and you never got your papers, for instance. You can be eligible for VAWA if you can show that that some of that abuse took place while you're in the United States, or while you come for summer vacations, and stuff like that. Sometimes, if in order for you to basically say, I never lived in the United States, at all, the abuse didn't take place in the United States at all, then you want to show that, your parent was in the U.S. military of some sort. But otherwise, summer vacations, living with your parent for a short time, you should be eligible to file for abuse. Another thing that's also a requirement is that good moral character is still a requirement for children who are filing. There is an assumption that if you're under the age of 14, that you have good moral character. But once you turn 14, we're going to need good moral character reference, whether it's in the form of an FBI clearance search or a police record, school records, part-time jobs, full-time job records, to show basically that you don't have criminal records and that you have good moral character. One thing that I would point out for those who are adopted, in the past with adopted children, when they're submitting VAWA applications, they still needed to show that the parents had the 2-year resident requirement. USCIS has removed that. So you don't need to show an extended period of time living with the parent for an extended period of time. So basically, these are the requirements, to self-petition based on you being the child of a U.S. citizen or a green card holder who has been abusive to you. And then keep in mind, for those of you who have come into this country, documented or undocumented, you will still be eligible whether you came in with inspection or without inspection. And, that's that. I see some questions here. I will jump right into the questions. Let's see. Let me just scroll through and get all the questions. How long does it take to get an approval after submitting medical exam? Brooklyn, every office is doing things differently, but I will say that if it's been more than 120 days, you definitely want to make an outreach to the field office to see what's going on. I know, for instance, in Orlando, one of the things is that right now they're collecting information from those of us attorneys who they've asked our clients to submit their medical so that they can look into it to see what's causing the delay, because ideally they don't want it to be more than 120 days, which is basically 6 months, before they make a decision. When can a citizenship application, when can I apply for, let me see if I understand your question. Okay, you're basically asking, this is for you, Haiti Toller. You're asking when can you apply for citizenship after you submit a 2-year removal of condition application and you go to 4-year extension. And this is what I'm deducing from what you've typed. Basically, the answer will depend on what kind of application you applied. Did you apply for removal of condition as a joint filing with your spouse, or are you doing it based on a waiver? If it's with your spouse, then you count 3 years from the date that you got your first green card, but you still have to make sure that other requirements are met, which is one, that your spouse has been a U.S. citizen for 3 years, you guys have been married for 3 years, and that you've had your green card for 3 years. So the rule of threes, basically. If you are filing based on removal of condition based on divorce, then you have to wait 5 years. If you are filing based on abuse and extreme cruelty, then you can also do it in the 3-year timeline. Okay. T-Mal says, hi from the city of Los Angeles. Is it okay to divorce your spouse while your VAWA case is ongoing? That doesn't affect your case. Divorce is a very personal decision. And I definitely have had some, I don't know what to call them, some random people that come on my timeline and say, basically, if you're telling people about VAWA, you're promoting for people to get divorced or not. I have never promoted for anyone to get divorced, and my clients will tell you when they ask me, is it okay? Should I divorce my spouse? I tell them it's not my marriage. You can decide to do what you want to do. However, I do answer questions when people ask me. So if the question is, does divorce affect your VAWA case while it's ongoing? If the divorce happens while it's ongoing, the answer is no, it doesn't affect it. However, you making the choice of divorcing would be up to you. Sometimes we will tell our clients, depending on the situation from a strategic standpoint, to hold off on a divorce, depending on the case and what is happening. And if that client has let's say we get an NOID or we're really struggling with stuff with the client and we want to make sure that the client has an opportunity to reapply again before the divorce window passes, we may say to the client, just hold up. This would typically happen when clients come to us after they already filed like a bad application and we're not feeling confident about the application they filed. And, basically they are coming to us to fix like an NOID or something like that. So those are the times that would typically happen. Fluffy says, good morning. Can you travel with your green card if USCI is printed it with a category error? What I recommend is if you know that your category is wrong, what you can do, and you're sure that it's wrong, what you can do is you can send it back to USCIS, but you can also go get an info pass. That way, while your green card is being republished or reprinted, they can stamp, a green card on your, it's called an I-551 stamp, which is basically a green card on your passport so that you can then be able to travel with that, okay? What happens when you go to a green card interview and they don't give you an answer, yes or no, and it says your status is being actively reviewed, but on my side, interview went well. Well, congrats that you believe your interview went well. I will tell you this, there are very few times that an officer will give you an approval on the spot. Contrary to belief, they do it, but it's not as often as people think. So sometimes they still have to go over the file and make a decision. If I would say after 90 days, maybe you've not heard anything, it's a good time to do like a soft inquiry to just see, what's up, what's going on in the case. And some officers will tell you, don't reach out to us in like 60 days. It's not going to take me that long, but let me just review the files. And I know sometimes if people don't hear that on that day or hear a decision in that week, they panic. But we've had people with absolutely no issues getting approved at month 5 or post interview or right before month 6 of interview. So sometimes that happens. But after 90 days, you can of course reach out, if you've not heard anything. But hopefully it won't take you that long. I got married to my husband in September. My husband went back to Jamaica and returned in November. I'm starting the paperwork. Is it safe for him to travel back to Jamaica while the papers are being processed? Marva, I'm assuming your husband is the immigrant. I'm just going to make that assumption. If your husband is the immigrant, he cannot, once you put in a green card application, he can no longer leave the United States until he gets a travel permit approved. If he leaves the United States, they will deem it that he's abandoned his application. And then depending on how long he might have overstayed while the case was pending, he would have accrued unlawful presence. So please, if you put in the paperwork, he has to wait until he gets a travel permit, okay? Abiola Labil says, after VAWA green card interviews, how long does it take for them to make decisions? With VAWA cases, very quickly. If you are scheduled for, so I would say that majority of VAWA approved cases that majority of VAWA approved cases end up getting an interview bypass. So like I would say in our practice, we see about 70% get an interview bypass. 30% will get an interview. And sometimes it doesn't mean anything is wrong. Sometimes it might be because they have a file there or they had your previous case there or there's just nothing. It just depends on the officer. In those cases, generally, they're very quick because a core portion of your application has already been approved. If they're delaying, if your VAWA case after a 485 interview is delayed, I can bet money on it. There's usually something concerning in the filing. That's your I-485 that makes you makes it a potential issue, and they're reviewing. Sometimes, because basically think of it this way. After VAWA, your I-485 form that they're reviewing, they're looking for grounds that make you inadmissible to the United States. Inadmissible is just a legalese term, basically saying ways that make you not eligible for a green card based on that form. Sometimes it could be new criminal records. Sometimes it could be something related to something, like you went and remarried somebody else, or there's a question about something related to like a previous divorce or something or discrepancy. But those are the things that they're looking for generally. So if it's taken a long time, I would be concerned for sure. Bomi says, any reason USCIS will send me a letter if I don't have a pending application? I currently have a conditional green card. I mean, they could be sending you a renewal, like a renewal reminder, a removal reminder reminding you that you have to file for removal of your 2-year requirement. After biometrics, how long does it take to get an employment authorization? Honestly, it varies. So it's hard to really give you an exact timeline. I filed for VAWA in 2021, December. So you're just at about 2 years. I got my prima facie July 2022, and it's expired, but I haven't gotten a renewal yet. And it's past the 60-day. No, it's not a cause for concern. And I've talked about this ad nauseum. A lot of times mails get lost. USCIS forgets to send the prima facie, but they don't like renege a prima facie. Meaning if you got your first prima facie, you have your prima facie. Instead, if they have an issue with your case post prima facie, you'll get an RFU and an NOID, not a reneging of the prima facie. It's just they've just not mailed it, or it's lost. But if you're the kind of person who's a worry, you just need to see that letter like in front of you. You can certainly be like, hello, I never got my prima facie, the second one, can you please send it? If you are using a lawyer can send that for you, or you're going to have to do a snail mail to USCIS. Thank you. The person that said she loves my hair. Thanks. All right, let's see what other questions I have. As of right now, how long does it take to get a work permit through marriage? Work permits through marriage could be anywhere from like 4 to 9 months. You can fall anywhere within that window. We're definitely seeing a lot of like 4 to 6 months on average, being the average, but really anywhere within that window is normal. Christine says, how long should you wait to hear from USCIS after their home visit to your house after an interview? A long time. Okay, I'm being funny, but usually once your file has been moved to fraud unit, it usually takes a long time for them to do an investigation. There's no published timeline of that. It's just up to them until they finish their case. I mean, if your case has still been unreasonably delayed, you still want to do a congressional assistance at that point to see if they can assist you in helping them get a decision. I don't know how long your case has been pending. Hopefully that home interview went well. Sean Smith is asking a question related to my topic today, which is about filing for VAWA as a child self-petitioner. And the question is, are there any exceptions if you're over 25 years old? No. T-Miles says, if you file for VAWA, are your kids from your previous marriage covered under VAWA? Yes, this is actually a very good question. So earlier, my topic today was about you being a child, filing a self-petition based on being a child or a stepchild or an adoptive child of an abuser who's a green card holder or an LPR, which is an LPR or U.S. citizen. The other category where children can get a 10-year green card through VAWA is if their parent is a self-petitioner. If your parent qualifies for VAWA and you are under the age of 21, if they get approved for VAWA, you'll get approved for VAWA. You don't have to do anything else. In that case, you don't have to have lived with the person. Your parent doesn't have to have married the person before you turn 18, but you will be covered under that. Now, once you're approved, you still have to go through and submit an application for either adjustment of, not once you are, once, let me correct myself. You can file for adjustment of status simultaneously at the same time as your parent if you are in the United States. If you're under 21 and your parent is a principal self-petitioner. If you're outside of the United States, you will be automatically included in the VAWA portion, but you're going to need to transfer your approval to the National Visa Center and then put in your application for your visa, in your home country for consular processing. You can proactively do the transfer request and pay the transfer fees that, should you be approved, transfer this at the same time the parent is doing the original application, or you can wait for the parent's approval to do it. People do it differently for different reasons or budget reasons. Guys, I gotta jump off. I'm running late to my next meeting, but it was nice chatting with you guys. And I will talk to you guys next time. Bye.